Hey everyone, it's Brad Polina and Lee Bergstein, and today we're jumping on to do a quick video discussing judgment enforcement and specifically how to bond a judgment pending appeal. We're very excited to have with us Neil Pedersen, who is an owner of Pedersen and Sons Surety Bond Agency, a surety bond broker specializing in bonds for judicial proceedings. Did I get that right, Neil?
That was perfect.
All right. Thanks for coming on today.
It's not that easy to say surety. It's a little tougher than you would think.
Yeah, don't ask me to say that 3 times fast. Anyway, so as I said, we're going to discuss judgment enforcement. We specifically want to focus on what it means to bond the judgment pending appeal. And Lee, why don't you tell us sort of why this is a topic that we think people will be interested in right now?
Yeah, so obviously the Trump case in New York County has been in the news for the last year and a half. Obviously, there was a judgment rendered against Trump and his family and the various entities involved in the lawsuit for $464 million. And last month, Trump's attorneys asked the appellate division for an emergency stay of the enforcement, which consists of the judgment itself and approximately $100 million in judgment interest. And typically, and Brad, you can talk about this in order to
post-judgment interest, right? 9% post-judgment interest. Every day that goes by, the judgment gets bigger.
Right. So in order to stay enforcement of a judgment, you would need to post a bond equivalent to the amount of the judgment plus the post-judgment interest. And Trump has actually offered out of the bottom of his heart, offered to secure $100 million bond instead. And I think yesterday, the Attorney General's office opposed that and asked the appellate division to insist upon the full judgment amount imposed in the bond. So, I think we're going to kind of use this particular fact pattern to talk through some of the issues relevant to judgment enforcement and posting a bond. So with that background, why don't we dive into it?
Yeah, Neil, maybe you could start by telling us what is an appeal bond? How does it work and how do you get one?
So that's a great place to start. An appeal bond is an extension of credit or a financial guarantee of payment. So the bond itself is not a risk transfer, it's a credit extension. Some people get confused with that. When we look at a bond, we're looking to the client to make an initial decision. Do they want to provide financials or do they want to provide collateral? Now, collateral in most cases is either cash, a letter of credit, or a pledge of publicly traded non-retirement account securities. Rarely is it real estate for appeal bonds. There are some companies that are willing to take real estate, but that's a very opportunistic situation, and companies charge very high rates for that situation. Now, outside of that, on the very large matters, it comes down to much more traditional collateral, such as the cash, letter of credit, or securities route. With that being said, some clients like to provide financial disclosure. Now, it's full financial disclosure, it's not partial. They provide, if it's a corporation, a profit and loss and a balance sheet. If it's a individual, it's a full personal financial statement, along with tax returns, bank statements, and other supporting documents so we could justify their values. So that's where we began. They provide me with the financials. I have the judgment. I then approach different surety companies that actively write this type of business. And then I take the terms that I obtain, bring them back to the client, walk them through them so that they can make the best decision for themselves of how to proceed. So that's really how it works. I would also say that bonds are for the more well-to-do, not the less well-to-do. So if someone can't pay, a surety is not going to extend them credit. If paying is going to completely wipe out their asset base of their operations, the surety is going to require collateral as well. So that's something to be aware of.
And I think that's all very helpful. And I think one thing that we should just be clear about, and correct me if I'm wrong, Neil, the reason you're talking about an extension of credit, collateral, the bonding company wants to make sure that the person obtaining the bond is basically good for it, right? And the reason that's important is that A judgment is just a piece of paper, right? It's up to the judgment creditor to turn that paper into money. But now when you go into and by enforcing it, finding assets and levying on them. But now when you go into the context of an appeal and you obtain an appeal bond to stay enforcement of the judgment, I think a critical point is that if the money judgment is upheld on appeal, that judgment enforcement effort stops and the bond pays out directly. Is that correct?
Correct. So there's also some things to note. If you have a bond signed by, let's say, both the surety and the bond principal, in theory, the creditor is supposed to make a claim directly on the bond principal first. When they refuse, they then can make a demand on the surety. So this is actually a question that comes up. How do I make a claim, or how do I collect on the bond? Well, you take the final order, provided there's no further avenue to appeal. You send a written demand to the surety. A lot of companies also have an email on the website as well. So I'd overnight them a demand and email a copy, and then the surety company pays out. So in theory, once you have it bond filed, judgment collection and judgment enforcement does stop. If it's in, let's say, New York State under CPLR 5519, where the automatic stay is. In federal court, it works a little differently. But yes, the judgment enforcement stops. Some things to note that comes up often. If accounts are restrained, the filing of a bond does not automatically lift the restraints. Your attorney is going to have to motion the court to have those restraints lifted. Right. And if the sheriff or marshal's involved, they can be entitled to their poundage as well.
So if we just quickly go back to the fact pattern in the news that Lee brought up, let's say Donald Trump or the debtors in that case get a bond. It's going to be very big, $500-600 million. It's going to include some amount of interest. If that order from Judge Engoron is upheld on appeal, that bond is now, the bonding company is now going to be liable to the state of New York for the full amount of the judgment plus whatever post-judgment interest has accrued, right?
Correct. Up until the amount that the bond is going to be fixed in. Because a surety company isn't going to leave an uncapped amount. So there's probably going to be a clause somewhere in the bond, provided, however, this bond is not to exceed X amount of dollars. So they're going to be.
That's a good question that we've actually had clients ask us from time to time. How do you decide on the full amount of the bond? What is there a I guess an industry standard or an accepted customary amount for post-judgment interest that an appeal bond should have? Appeals can take a while, right?
They can. So there's no industry standard. It varies by jurisdiction, but just focusing on New York State, in CPLR 5519, there's no specified amount. It just says that you have to include costs on appeal, which 9% statutory interest is a cost. So what I suggest to my clients is come up with a reasonable amount that's not going to be challenged. A lot of times that could be 115, 120%, maybe 110 under certain circumstances. But it's really up to the other side to challenge the amount of the bond. And if they don't challenge it, whatever amount you put forth is accepted. With that being said, going in with a 50% bond amount or going in with a bond that's 101% really doesn't make any sense. So I try to stress to my clients, that they need to come up with an appropriate figure. In the past, my clients have used 120%. Some accept that, somewhat less. I also let them know that I don't take on any liability if this is thrown out. So there's got to be some sort of number that makes sense for that individual appeal, or that you could at least back up and justify.
So just bringing it back to the Trump fact pattern for a second, because that's just kind of a fun one to talk through, although somewhat unique, obviously. How easy, difficult, challenging will it be for him to find a surety to post a bond for him? I guess it's for him and the various entities who are the judgment debtors in this action. How difficult will that process be for him?
So it's going to be actually very challenging. It becomes very easy if you have the full amount of liquid assets to put up as collateral. But if you don't, it's going to be an extreme uphill battle for a couple different reasons, and I could definitely get into that. Earlier I mentioned that this is an extension of credit. A surety company relies on what's called an indemnification agreement. It's generally referred to as a general indemnity agreement. If you have an indemnity agreement from an individual that is possibly then in the White House later this year or next year, It's impossible to, and it's not impossible, but it's a lot more difficult to enforce that indemnity against a sitting U.S. president. So the not being convinced that you could execute on the contract is a major issue in extending anyone credit. And then separately with this individual case, the individual's asset base is heavily in commercial real estate. We're going to a extremely challenging commercial real estate market, and the values of a lot of properties are uncertain. And at the end of the day, on the back end, a lot of these properties also have first and second mortgages. So a surety coming in as a second or third position on a property is not a preferred place to be. So there's a lot of issues to get this bond, but I think it's going to come down to what liquid assets they have to put up.
I have one kind of follow-up question on the White House piece. Correct me if I'm wrong, but a surety bond has a term attached to it, right? Is it possible to create like a custom term that expires on the date of a potential inauguration to limit the exposure for the surety company?
So in theory, yes. In practice, an appeal bond should have no term or expiration. So if you receive an appeal bond with a term or expiration, that should definitely be challenged.
Mm-hmm.
And if, really once the bond's filed, you cannot unfile it. So with surety underwriting, which is why they're so conservative with appeal bonds, is that, once we start working together, there's no way out until that judgment's either overturned or satisfied. So the short answer is no. If you're a judgment creditor's attorney, why would you accept that? And if it were accepted, you would make a claim a couple days before it's set to expire.
All right. Well, I think we've hit a lot of the high points here. We've weaved our preferred fact pattern in. We want to thank you for coming on with us, Neil. If someone watching this wants to get in touch with you, they have a need for either an appeal bond or some other kind of bond. I know you do mechanics lien, discharge bonds, injunction bonds, probably a list of 100 other types of bonds. What's the best way to contact you? Can you tell us what your website is?
The best way is to go to my website, courtbondnow.com. That's COURTBONDNOW.com, or 212-227-7277. Give me a phone call, send me an email. I'm available.
Maybe the former president is taking some notes while we're recording this. So you have a tough decision to make in the near future, I guess.
Certainly will.
Thanks so much, Neil.
Take care, guys.